All right, we are on the record. 462464. Mr. Willick, your appearance, please.
Good morning, Your Honor. Marshall Willick, 2515, for Ferrick Kaufman, formerly known as Ferrick Gibb.
Thank you. Mr. Gabato?
Morning, Your Honor. Alex Gabato, 10592, on behalf of Kristen Gibb.
Thank you. We are on today on, this is Mom's motion. The court has reviewed the motion, reviewed the response that was filed, reviewed the 2016 order, as well as the reply. So, what else do I need to know?
Your Honor, if this is mine, I will try very hard not to repeat anything. There is one substantial mystery from the paperwork, which is why I presume you moved this from the Chamber's calendar to an in-court hearing, and that is the three contradictory statuses listed by Mr. Gibb and his counsel in their filings. They have said simultaneously in the opposition at page 4, I think, that Mr. Gibb is retired, has been for 4 years, and is currently receiving military retirement benefits. His FDF says he is now employed by the United States Air Force and has been continually so since 2002, although actually on information and belief that date is 1997. And his letter, which is in the exhibits at Exhibit 2, Bates Stamp 11, says that any OID, Military Retirement Benefit Division order, would be premature because he won't be eligible to retire for another 15 years. So one of the things we would like the court to do at this point is to swear Mr. Gibb in and ask him a couple of questions about his status so that the contradictory representations as to his status can be established. He should have 2 weeks to provide all relevant documentation, including a cumulative point summary if there has been any reserve time, or the court should order a 50-50 division of all military retirement benefits earned as a sanction for his refusal to provide information to allow a more precise calculation to be done. That information has been requested and has been refused. We also ask the court at this time to open discovery. Given the level of evasion and duplicity, we are going to want to issue subpoenas to verify any information provided with the military offices, no matter what it is that is actually produced at this point, or refused to produce. That's military retirement benefits. Once we have that information, I probably will have some further comments about what should be done. If it's true that he's been retired for 4 years without giving any notice of it and without complying with the portion of the decree requiring him to divide the military retirement benefits 65-35 with my client, then we would be, of course, seeking an arrearage calculation for the amounts that have been received. But since we don't know what the facts are, I can't provide that calculation, and I can't provide a specific request. So a further motion may be required if the court deems it necessary.
Okay.
Moving on to the second. I'm sorry?
I said okay.
There are, in my opinion, 7 issues. I'll just roll through them very quickly. Most of them are pretty short. On the SBP insurance issue, the question really for this court is whether the court believes that Judge Duckworth's rumination, his jurisdictional error in belief, permits revisiting the insurance order from 2016 today. He was under the impression that he lacked jurisdiction to order the SBP. That's incorrect under the law. He has that ability under 10 U.S.C. 1457 specifically. Oddly enough, and I'm going to be circling back to Peterson in a moment, Justice Hardesty asked exactly that question during oral argument about 4 months ago in the Peterson case, and I gave him that full information, and that was part of the reason for the Peterson holding, which I'm going to talk about in a moment. But The question is whether that jurisdictional error permits revisiting the insurance order from 2016 directly. You may have to visit it indirectly, which I'm going to get to in just a second. But if you can get to it directly, then FARA should probably be made the SBP beneficiary as the omitted asset of the SBP. If not, if the court doesn't believe it can revisit Judge Duckworth's order in that regard, then Kristen should be given 30 days, not a day longer, to get the medical exam that has been requested of him repeatedly since 2017, so that the insurance that Judge Duckworth ordered can be put into place. I asked the court to review Exhibit 11, including Bates stamp page 50, for his continual evasion and refusal to actually do what is necessary to allow that insurance to get into place. At this point, the insurance agent and Ms. Kaufman have attempted to get the insurance in place by requesting that he cooperate during visits, on weekends, at work, at his mother's place, at several other locations. There is documentation in the exhibit of at least 25 attempts to get him to comply with Judge Duckworth's order to submit to a medical exam sufficient to allow the insurance to go into place, and he has evaded it continuously for 3 years. This is very similar to a case this court saw about 3 weeks ago, and the answer is enough is enough. He gets 30 days to do whatever he has to do to get the examination to allow the insurance to go into place, or one of two things should happen. This is the indirect route that I was talking about. If the information we get about his status indicates that he is still active duty and he has not in fact retired, then the court, as a sanction, should order Ms. Kaufman, the SBP beneficiary, as a means of enforcing Judge Duckworth's order for insurance by alternate means. If he is retired and the SBP has been locked by being made a benefit payable to a third party, presumably the current spouse, then after 30 days, if he has not done whatever he has to do to qualify for the insurance, including the information released from the military and submission to a physical examination, which involves a blood and urine draw, but not the other things that his evasive email said that they were requesting, which they are not requesting, then after 30 days, a bench warrant should issue for him to be jailed, at which time, in custody, the examination can be performed, so that there's no longer a way for him to continue evading it.
Okay, are you indicating, Mr. Willick, that the February 5, 2016 order requires the insurance?
Yes.
Okay.
Here's the quote. February 5, 2016, court entered an order saying, the issue of the retirement benefits was adjudicated, and given the cost, it would make more sense for the plaintiff to secure and maintain a life insurance policy, which would be at her cost, to secure child support and her portion of the benefits under the retirement plan. The court does not believe additional expenses should be incurred to prepare another DRO. Both parties can submit their competing orders to the court. Alternatively, the parties can submit the order from Mr. Snyder. So that's the exact statement. It's not the most tight language, but I do notice that Ms. Kramer was charged with writing that order. So if there is any deficiency in the specificity of the order, it falls to Mr. Gibb, because it is the fault of his counsel for not being adequately specific.
Well, didn't Judge Duckworth suggest maybe competing orders if there was going to be some concern and there wasn't a competing order submitted by your client? Because in the order section of the February 5th, 2016, there's no mention of life insurance. It appears from the minutes that Judge Duckworth was ruminating about it, but I don't think he was directing, I could be wrong, I didn't watch the video, but I don't think he was directing that the insurance be obtained. I think he was suggesting that it may make more sense to obtain a policy of insurance.
Okay, I don't have a copy of the order in front of me. If you're saying that the quote that I was given from my staff is from the hearing video and not from the actual physical order, then yeah, there appears to be a deficiency in the order itself.
Yeah.
But of course, the court has inherent authority to construe and enforce.
Yeah.
And since this is an exact quote, I didn't realize it came from the video, not the order.
Well, it may be, and it may be from the order. I didn't see it as I was scanning through it, but there's an order section in the order and what is ordered, and it looks like the first part is more findings than order. But when you were reading it, I couldn't find what you were reading, but that doesn't mean it's not there. It appears to be more of a thought process from the judge rather than a specific order, at least the way that I'm reading that order. So there may be more to it than that, indirect versus direct as well. So I just wanted to clarify.
Sure, I'll apologize for that imprecision in our materials. I can get the court an exact citation, but my staff would not have provided that exact quote if it didn't come from something.
No.
So it's either from the order itself, which is what I thought it was from, or it's from the hearing video. I would presume it's from the order, because if it was from the video, I would expect to see a citation to a time index.
Right.
So I think it's in there somewhere, but I don't have that order in front of me. I can provide that after the hearing if the court wishes.
Yeah, and I think if I'm looking at the bottom of page 3 on that order, it looks like it's part of findings from just preceding the actual order itself.
Okay. But I would still lay she thought it was adequately specific to be enforceable, which is why she sent the insurance agent to contact Mr. Gibb, which the insurance agent did over a period of several months, apparently, throughout 2017. And we have supplied the entire back and forth email exchange in Exhibit 11, showing Ms. Kaufman's contact with Mr. Gibb, the insurance agent's contact with Mr. Gibb, Mr. Gibb's continual refusal to actually comply while stating, presumably on advice of counsel, that he had every intention of complying but never actually doing it. So at this point, we are simply seeking to enforce what we thought was an existing order. But if the court doesn't believe the pre-existing order was adequately specific, we will ask at this time for a clarification sufficient to order him to do the things we're talking about within 30 days on pain of contempt.
There's no order to be held in contempt for. None. We just talked about how there's no order. How's he going to be held in contempt for an order that doesn't exist?
I just said, if the court doesn't believe it's adequately specific, then please enter that order now. Give him 30 days to comply on pain of contempt. That would be the specific order. Again, what we've got is
Mr. Gabato, it's not your turn. I will give you an opportunity. Let Mr. Willick finish.
We have a multiple year evasion and refusal to comply with what both parties in their written communications termed an existing order to allow the insurance to go into place. If he was simply playing her along and now wants his lawyer to say, ha ha, we were lying the whole time, there is no enforceable order, so he never had to do what he promised to do, fine. We'll ask the court to make it an enforceable order and to enforce it accordingly. We're not asking for a contempt sanction at this moment. If that's it for that issue, I'd like to move on to the next.
Okay.
The Thrift Savings Plan. We noticed that there is no opposition to our request in the opposition. So presumably this has been conceded and doesn't have to be argued, but there are some new relevant citations which the court should be aware of. About 3 weeks ago in Peterson versus Peterson, May 22nd, 2020, in case number 77478, a unanimous en banc Nevada Supreme Court holding found the Thrift Savings Plan, which was not specifically recited in a decree of divorce, be an omitted asset requiring partition upon discovery and request to the court. That citation is not in our materials because it hadn't happened yet when we filed the motion, but the facts are almost identical, just the timing is slightly different in that case. And there is no doubt that the Thrift Savings Plan, if it existed, and if there were any deposits during marriage, constitutes an omitted asset under NRS 125.150 sub 3 to be partitioned upon discovery at this time.
Mr. Willick?
I'm sorry?
I said, Mr. Willick, the TSP is specifically referenced in Dad's July 15, 2013 financial disclosure form, Wouldn't that have been a sufficient disclosure to require your client to have taken action before now on it, on an omitted asset?
No, that was actually part of the reasoning behind the statute. I'd refer the court to the legislative history of 125.150 sub 3, because exactly that request, well, exactly that statement was what Judge Moss found to be an adequate disclosure, giving a duty of discovery to the other party in one of her two contradictory rulings in Doan versus Wilkerson. Doan versus Wilkerson went to the Nevada Supreme Court in 2014 and resulted in a decision saying that some disclosure of the existence of the asset during the course of the litigation constituted enough of a disclosure that there was no right to partition for the omitted asset. That case was specifically reversed by NRS 125.150, as the Nevada Supreme Court has explicitly found in a later case. I don't have that citation in front of me, but I can give it to you. They have found that the purpose of the statute was to reverse the holding in Doan, which had that reasoning to it. So no, his providing in discovery some information indicating the existence of the asset is no longer the standard. 125.150 sub 3 was specifically written to prevent any such finding. I mean, I wrote that statute. The full explanation, the legislative history, and the references to the references which lead to it are recited in detail in the article Partition Actions, What Every Nevada Lawyer Needs to Know, a CLE done December 3rd, 2015, which is posted on our published works page. As an aside, it explains how the statute explicitly makes irrelevant the holding in McCarroll, which is relied upon in the opposition filed by Mr. Gabato. The burden under the current statute is explicitly on the party asserting it, that it was considered to prove that it was specifically bargained for, by whom, and where that bargain is recited in writing. And if they can't fulfill that burden, then it is an asset subject to partition. The burden has been shifted to the possessory party to prove that it was bargained away. Not that it was disclosed, not that it was discussed, not that the other side could have figured it out from some discovery or production or listing somewhere during the litigation, but that it was specifically considered and disposed of in the prior case. And if they can't fulfill that burden, then it is to be partitioned upon discovery. Farah first discovered that a TSP plan existed when she spoke with my Quadromaster staff within the last 12 months. So she had no idea, there was no bargain, there was no consideration. It is an asset that he simply pocketed walking out of the divorce. You know, it's irrelevant, but a TSP plan is not on a pay stub. You know, there is no balance statement. And as are indicated in our filings, Mr. Gibb filed his first FDF apparently long after the decree was filed. In terms of the TSP, and by the way, the TSP, I mean, that's the holding of Peterson. And exactly the arguments that the discussion we just had was the oral argument before the Nevada Supreme Court about 3 months ago, as they asked exactly that question. And that is the ruling in that case. He can get the full information necessary online in about 10 minutes.
So there's no statute of limitations to providing that information and seeking a reimbursement once you learn of it?
3 years from the discovery of the fraud or mistake indicating that it could have been divided and wasn't. And she has stated, regardless of any notice, that she didn't know what it was, that it existed, or that she had a right to it until a few months ago.
Right, but that's why I pointed out a minute ago, post-decree, in a 2013 financial disclosure form, the TSP was referenced. So are you telling me that Peterson indicates there's no statute of limitations on when she has to take action on that?
The statute of limitations is 3 years from her discovery. It's a discovery rule. The fact that it was disclosed and she could have investigated and possibly found out about it was the matter overturned in the statute. The statute on its face now places the burden of proving that she knew about it and that she voluntarily chose to not divide it on the party who is possessing it. The burden has been reversed explicitly by the Nevada legislature as revealed by the legislative history of the statute. That was the purpose of the statute, because exactly this conversation was what happened in Doan versus Wilkerson, which the statute was designed to reverse, which has been found to have been reversed by the Nevada Supreme Court. She doesn't have a burden to figure it out from a disclosure somewhere in the divorce litigation. He has the burden to show that it was before the court and explicitly dealt with on the face of the decree. And if it wasn't dealt with on the face of the decree, his burden is to show that she explicitly bargained it away. He can't, because she had no idea this thing existed.
Okay.
So the statute is quite clear. The purpose of the statute is quite clear. I'm intimately familiar with the legislative history, and there is no real doubt, regardless of a disclosure somewhere in an FDF back during the divorce, that the burden is on him. He cannot satisfy that burden because this is something he simply got away with, which is what the statute was designed to prevent. So that was exactly what the service member said in Peterson, that, oh, well, she must have known about it and must have decided not to pursue it. And that came up at oral argument 90 days ago. But we now have a unanimous decision saying that is not how it works, because that's not how the statute works. The statute puts the burden on the possessory party to show actual disclosure of the precise asset and that it was disposed of in the decree. And if he can't, then the asset is to be divided if the non-possessory party figures it out and files something within 3 years of the time they figure it out. And she has. She has satisfied her burden, and at this point the asset is to be divided. So what we ask for on this point is for him to produce all information regarding all deposits to the TSP during the marriage, which he can do online in minutes. And we ask for discovery to be open so that we can verify the legitimacy of that information. Because,
Your Honor, may I interject on this point before we move on?
You have, what is it, Mr. Cabata?
So there's a case that's being cited here. There's discussion as to legislative history and such. It's not in the pleadings. I've not been able to brief it. I just looked at the Peterson case as Mr. Willick was speaking, and nothing of the sort that he says happened in that case. The reality is that the litigant there just agreed to limited remand in the briefing on that issue, and it was remanded. It wasn't that a decision was made. And so if we're going to continue on with Mr. Willick pulling cases that aren't cited, that aren't actually briefed, and citing legislative history, I'd like to continue this so that I can further brief the matter. It's just not fair to my client for this to be allowed. I don't want to have to sit here as Mr. Willick is waxing eloquent, trying to fact check the stuff that he's saying, because I know from experience that the stuff that he says about what cases say or the facts of the case are not always accurate, to put it mildly.
Well,
so if we're going to continue down that road, we need to continue this so I can brief the cases that he's citing.
Well, and certainly if the Nevada Supreme Court has recently come down with a decision, I'm not going to be able to render a decision today until I have an opportunity to review it. So,
right.
Mr. Willick,
and I'm looking at it, it has nothing, it doesn't say what he says, so I think we should continue this at this point.
Addressing the TSP, the district court found that James had not contributed any marital funds to the account and thus refused to adjudicate it as an omitted community property asset under 125-150 sub 3. But the record does not contain substantial evidence to support that finding. The district court relied on counsel's representations that James hadn't contributed any marital funds to the account. But that's not evidence. James conceded as much when he agreed to a limited remand on this issue in his appellate brief and during oral argument. We therefore reverse the district court's order as it pertains to the TSP and remand for further proceedings. See Ogawa.
Because he agreed to it, not because they held anything.
I don't need argument. The only question I'm seeking an answer to right now is, does it make sense to continue this hearing so that the court has an opportunity to review Peterson before we finalize this?
I have no objection if you wish to do so, Your Honor, but if you want the legislative history, I'd refer you to the article, which is the simple, easiest way of getting it. The article was specifically written as soon as the statute was passed, resolve questions exactly like this one, recounting every case that went into the history of why this statute was written and what its intended effect was. I can supply that as for convenience. I
do believe Mr. Gabato should have an opportunity to respond to it, and the court should have an opportunity to review it as well. So why don't we move this out? Is a week going to be enough time to take a look at it, Mr. Gabato?
That'll be enough for me, Your Honor. I think, though, at this point, if Mr. Willick intends to cite any other cases, he should put something on the record in writing and then let me respond to that.
I have no objection to filing a supplemental exhibit with the citation from the insurance quote that we got to earlier and the Peterson order and the legislative history as recited in the article. I can have all three on file within the next 24 hours.
I think that would be very helpful.
I think it would. And
but
if he intends to use any other cases in a future hearing or any other cite to anything that's not in the record now, put it down now.
My suggestion, Your Honor, would be to complete the recitation of the 7 issues to see if there's any other points of dispute, anything further that the court wants, just so we don't have to repeat this exercise in a week or 2 or 3.
That's fine.
Fourth issue, excuse me. MRBs, SBP Insurance, TSP, issue number 4. The Air Crew Incentive Bonus payable 2016 to present. That is unopposed in the opposition and therefore conceded under the relevant EDCRs. The arrears calculation is in Exhibit 9. The benefits have only been payable since 2016 on the basis of the same case law that is applicable to the MRBs. No statute of limitations begins to run until the benefits are payable. We've been over this over and over and over again in this court and others. Under Davidson arguments, the statutory site is set out in our materials, and we simply ask for those amounts to be reduced to judgment payable immediately.
Yeah, and my concern with this provision is it's not clear to the court whether it's just 2016 or whether it's in perpetuity.
If the court has to construe it, the court has to construe it. We've given you a calculation of arrears from 2016 to present because that's how we believe it reads. It wasn't addressed at all in the opposition, so we don't have an opposing view of how to construe it. But if the court has some concern and wants that matter addressed, we can, they can, we both can. We'll take whatever direction the court wants, unless you simply want to review.
And that is a concern that I noted as I went through, is that it's the drafting of it is not clear. I could make a straight-face argument for a period of time. I could make a straight-face argument for 1 year. But in perpetuity, it doesn't deal with when he stops receiving it. It doesn't deal with, I mean, there's some problems with that as well. Certainly, the minimum would be what was in 2016, but beyond that, I don't really have a lot of argument with regard to that or what brought us into that. That's the provision that concerns me from an interpretation standpoint more than anything else. The rest of the issues, I think, Mr. Willick, are admittedly legal analysis issues. This one seems to be more of a drafting interpretation issue.
Since there was no opposition, I didn't respond to it in the reply, but if the court will permit me to expand the filing that I'm going to make, I will go back to the MSA, find the exact language. It's a very lengthy MSA, which is then partially receipted in a decree. And I can't tell the court as off the top of my head that I remember the exact words used. So since that's a concern of the court, I'd like permission to address it, and I'll go back and dig out the exact words in both documents.
Yeah, I'm looking at the words now, so certainly if you need to comment on that, that is something that the court had additional concerns about when reviewing this case, and another one of the reasons why it was taken off of the chamber calendar.
Okay. Then I'll take another look at it, but I'm sorry I don't have that information, memorized to be able to answer that question right now.
Okay.
Your Honor, if I may very quickly, very briefly, on this issue, again, Mr. Willick has responded or mentioned twice that there's no mention of these issues in the opposition. There is. Section D of the opposition addresses the life insurance issue, the incentive bonus, all those things.
Yeah.
And Section E is a note on the SBP. So it is addressed. So I just want to make that record clear before he goes on, because he said it twice. It's not addressed if it is.
Okay.
Next issue, life insurance of $400,000 for the benefit of the children. That's the MSA from page 9, item 5.3. We've given you in the exhibits documentation of repeated requests for verification that insurance is in place, all of which requests have been ignored. Once again, Mr. Gibb's status is relevant. If he's still active duty, which is possible depending on which of his three contradictory representations is true, then he has available to him SGLI, which if the children are named beneficiaries would probably be adequate. We note that the number that was chosen, that 400,000 number, exactly corresponds with the upper limit of SGLI coverage. So it's possible that that's what the parties were contemplating when the provision was written. But since we don't know his status and he refuses to verify the insurance is in place, we would just give him whatever time limit the court deems relevant. We think a week is adequate, but you can make it 30 days to verify that the children are and have been named as beneficiaries under the under an adequate policy of insurance for $400,000 minimum. And in which case, if he has, great. If he hasn't, then he's been in violation for whatever time the kids weren't covered, including up to today. We simply don't know what the facts are because he's refused, which is another reason why whatever level of discovery and the court's order to directly produce the information would be relevant. Sixth, and possibly most trivial, our family wizard, the question is whether the court wishes, there is still one minor child. The court could choose to enforce the term of the decree by ordering him, again, this is a reminiscent of another case from just a few weeks ago with nearly identical facts, could order him to get on the OFW roll today. The request made in our motion was to reimburse the $100 she paid to enroll because he refuses to do so. But the court should address the issue one way or the other. And the seventh issue, and obviously that will have to be deferred until the court gets the other information and makes its ruling, is the issue of fees. Those are the 7 issues that we believe are properly before the court for today. We will, of course, answer any questions the court has after Mr. Gabato makes his opposition, unless the court wants to reserve that after further filings.
Well, and I think from what I got from Mr. Gabato, he would like to be able to review this prior to have to give his opposition. I would like clarification on whether we're active status or whether we're retired, Mr. Gabato. Can you provide that?
Yeah, he's currently in the reserve journal, and I'll let him explain his employment and retirement situation himself. And I apologize, I was going to, and I will supplement the filings with his affidavit because I was going to do that in an amendment and I never did. So that'll happen tomorrow as well, or within the next 24 hours. But go ahead, Kristen, explain to the court your employment status and when you retired, if at all.
Are you able to hear me?
Yes.
Yeah.
Okay. I'm currently off orders right now. My orders and leave expired yesterday, and my retirement will begin 1 September. And if possible, I'll address the other issues, but I don't know if I'm allowed to do that.
No, not right now.
Okay.
Okay. All right. Then
Could I ask if that's a
Go ahead.
Could I ask if that's an active duty retirement or a reserve retirement? Because we just now heard 2 contradictory statements from Mr. Gabato and his client.
Sir, is it?
I didn't make a statement.
Is it active? You did indicate something about reserves, but I don't know. There was some question on that.
There will be a 20-year active duty military retirement 1 September.
Perfect. All right.
Okay, so the representation from page 10 of the opposition that he has been fully retired from the Air Force over 4 years ago and has been receiving retirement pay since then is being withdrawn by our opponent as an incorrect representation.
That's right. That was my error. It was a version of the opposition that was supposed to, that had a subsequent edit, that I just filed the wrong version is all.
Okay, so Mr. Willick, you gave yourself kind of a tight time deadline at 24 hours. Are you still okay with that?
Actually, given the way we've expanded the number of things for me to supply, if I could have another couple days, it's not difficult. I just don't want to have anything go wrong. Today is Tuesday. If I could have through Friday, I can address each of the things the court's just asked about.
And you want an opportunity to respond, Mr. Gabato?
Yes, Your Honor.
And how much time do you need to respond?
A couple days from now, maybe 3-4 days. If he's going to file by Friday, if I could be given until Wednesday to submit a brief on the citation that he submits. And then I'll also supplement the pleading with an affidavit from my client.
All right, then what I'm going to do, I was hoping to get you in on the 24th, but that doesn't give us enough time. So why
I mean, I could do it by Monday, Your Honor. If you want to get us in by the 24th, I could get everything done by Monday.
Yeah, and I don't want to inconvenience Mr. Gabato. If you want to just have my deadline be Thursday instead of Friday, that'll give him an extra couple days. I'm not trying to make response impossible.
All right, then what I'll do is I'll bring you back on the 24th at 9 a.m. And if you can get your stuff in by Monday, Mr. Gabato, then it'll give me an opportunity to review it and be ready for the Wednesday hearing.
Will do, Your Honor.
All right, thank you both.
Thank you for the time, Your Honor.
Uh-huh.